Welcome. You're watching the India Development Debate. I'm Tamanna Inamdar. The Supreme Court judgment in the Essar Steel case is being hailed as a landmark verdict that will pave the way for how the bankruptcy code is implemented in India. After the Supreme Court verdict, it is clear that ArcelorMittal can indeed proceed with its takeover of Essar Steel. The decision of the Committee of Creditors, which is a group of lenders to a stressed company, is final, and secured and unsecured lenders cannot be treated at par. The Supreme Court has also effectively undone an amendment to the IBC law that set a limit of 330 days for resolution of companies that included the legal process. The resolution of Essar Steel, one of the dirty dozen, which is the top 12 defaulting companies, marks a huge movement in the journey to recoveries for banks, especially public sector banks, and to revitalize and save companies that have gone bankrupt. It's also important in the broader economic perspective where undoing the clutch of NPAs that is bogging down the financial sector is crucial, and this judgment will help in that direction as well. Joining us today to discuss the import of the judgment is Shardul Shroff, Executive Chairman of Shardul Amarchand Mangaldas and lawyer to Essar Steel COC, Abizar Divanji, Partner and National Leader, Financial Services, EY India, DK Mittal, former Banking Secretary, and Prabal Basu Roy, Management Advisor. Welcome to all of you and thank you for speaking with us today. Mr. Mittal, I want to just get your response first to how you see the judgment and the broader impact and import of what the Supreme Court has said today.
Well, Tamanna, thanks. This judgment clears one of the defects which were there in the whole process because of very variant views. So this is going to give a push to resolution of NPAs in very large cases which are pending before NCLT, and also there are some litigation going on. So this is very good for the banking sector, particularly when December end is coming and we expect a large number of other cases which are not getting resolved by that time. So this issue really, this judgment has come as a matter of big relief to financial sector, particularly the banking sector. And the other issue is about the 270 days deadline given by the RBI, so that is now clicking for a large number of NPAs. And I hope NCLT will take cognizance of that and will see that those cases are also decided on priority.
Mr. Mittal, let's just go into a little bit of detail when it comes to lenders. Now, there is still going to be a distinction between, secured lenders and unsecured lenders, and a large part of these also form the Committee of Creditors. Does this ensure that lenders don't prefer to move to liquidation straight away? Because if you had a situation where all creditors were on par, in a resolution scenario, would we have seen a situation where lenders would have preferred liquidation?
No, I would agree and disagree with both with you. One, that the Supreme Court decision, the COC, Committee of Creditors, is the final body, is absolutely correct. Secondly, nowhere, even under the Companies Act, when liquidation was happening under that act, the secured, unsecured and operational creditors were never treated at par, and they can't be, because if they were at par, then they would be at par only if they are taking same risk and same cover. So that's not the case. The rate of interest are different because they are taking high risk, so everything is different. So they cannot be treated at par. Now it is the COC which has to decide how much to be assigned to whom. There is a waterfall mechanism which is available there. They have to decide, and there is a voting pattern in COC. So if everything is voted in a very democratic way in the COC by the creditors, and that passes the COC as per the prescribed mechanism, then I don't think what Supreme Court has said is perfectly fine, that NCLT cannot tinker with it unless they find that some legal principles have been compromised. Otherwise, there is no end to it. So I think this issue needs to be settled. This has been settled, and this is in the best global practice, in line with the best global practice. What I feel sad is that the 330 days deadline has been set aside, which is a bad thing, because then you keep it open-ended. So the process of our courts is, as we are aware, the companies or the litigants try to take liberty with that and try to delay the judgments. So that issue, I think, is unfortunate that Supreme Court took a view, but then the Supreme Court is Supreme Court. we really can't say on that much.
Let me go across to Shardul Shroff now, who's joining us as well from Tokyo. In fact, Mr. Shroff, thank you so much for taking out the time to speak with us today on a very important day. I'm just going to start by getting your view on how important and path-breaking this really is. We're also trying to give our viewers a perspective of why this verdict is important in the larger picture of resolution and the entire IBC process in India.
So, Tamanna, basically, this problem arose from the interference by both the NCLT and by the NCLAT during the phase of restructuring or resolution, where the tribunals held that the principle of equality and equal treatment should be made applicable between operational creditors and secured creditors, for the reason that when this judgment and orders were passed, there was no provision contained in the law in relation to how this interim restructuring should be done. So the tribunal took upon itself to state that because the principles of insolvency and the waterfall under Section 53 was not expressly stated in the context of restructuring or resolution, the tribunal had the discretion to decide whether both of them should be treated as equal.
Yes.
Now, this caused a lot of furor in the international community, and in a period of 13 days from the date of the decision, the Ministry of Corporate Affairs amended the law and incorporated the principles of the waterfall under Section 53 as part of the rules applicable even in resolution. Now, this was during the pendency of the proceedings in the court, and the court wanted to decide the principles without the benefit of the ordinance and with the benefit of the ordinance. So what has happened by this judgment is that unequivocally the Supreme Court has said that at every stage of the IBC proceedings, whether it is in the stage of resolution and approval of the resolution or at the stage of winding up, the principles of Section 53 remain applicable. This is a very, very important judgment, because otherwise the banking community, the lending community were all extremely affected,
Yeah.
and would have changed the pricing of secured loans and unsecured loans, because the risk factor in relation to a secured loan and the measurement of interest are significantly different if one takes it on the basis of an unsecured debt or a secured debt. So this is the landmark aspect of the judgment. The second aspect, as has been discussed before by Mr. Mittal, is that the primacy of the Committee of Creditors in making a decision as to what should be the contours of a scheme has been restored.
Right.
Even previously, in the Shashidhar case, the Supreme Court had said that the ability to decide on how the resolution should happen, the ability of how distribution should happen based on the payment that the parties are offering, the basis of maximization of value that is central to a theme of restructuring should be the basic criteria. And as long as those basic criteria are maintained, the tribunals have no power to change the decision of the Committee of Creditors. They have only the power to examine as to whether any of the fundamental aspects of the IBC, namely the manner in which priority has to be given to a dissenting financial creditor, or the basis on which within 30 days you have to pay the operational creditors. Those aspects are what have to be scrutinized now by the NCLT and the NCLAT. They don't have the power to rewrite a scheme. They don't have the power to control the distribution
Right.
of the monies received. These are the salient features of today's judgment.
Mr. Shroff, I'd just like to get your perspective from the other side. Through the day, we've been hearing about how this is a victory, a sigh of relief for financial creditors, for the entire financial system. I just want to look at this from the perspective of operational creditors, because the Supreme Court has also held that operational creditors are vital and key. Going forward, how do you see an assurance that operational creditors and their interests will also be taken care of, and will a COC in any case, I mean of course in Essar or in other cases as well, be able to and willing to take into account the rights of the operational creditors?
See, under the law and what has been affirmed by the Supreme Court, it is quite clear that an operational creditor or a trade creditor has rights inferior to the rights of the secured creditor. The committee of creditors comprises of both secured creditors and unsecured creditors, and they are called upon to decide the application made by a resolution applicant of revival. Now, in the scope of revival, it is not merely the security or the debt recovery of the secured creditor which is relevant, because the company has to run as a going concern. So when a scheme is drafted, it is incumbent upon the committee of creditors to see that those unsecured creditors, those unsecured financial creditors or trade creditors have some part of their payments assured to them. So whether it is 10%, whether it is 20% of the total payment that a resolution applicant would be making, that is a judgment call that the committee of creditors has to take. Because if you give them zero, there is hardly any possibility of the company reviving, because nobody is going to give you supplies of either goods or services without receiving any payment, and that will affect the manner in which the company will be impacted. So there is an assumption of fairness, not in the sense of equality, but in the sense of common sense, that if you are going to keep the company alive, then how are you going to have your supply chain in place? How are you going to have your services in place? Who will supply you goods without making payment? And what is the optimal point up to which they should be paid so that their future is secure and that they don't go belly up themselves? This is the aspect that has to be considered by the committee of creditors, more on prudence, more on common sense, rather than by virtue of the law. So when the courts discuss this, that there must be a sense of fairness, it is not fairness in terms of equality, but
Okay.
it is fairness in terms of operational possibility. If they can't function because they don't get any money, they will also fall as dominoes. And that is the effect which should be prevented in a revival.
Absolutely. I also have Abhizar Divanji with me, top corporate lawyers on the India development debate this evening on a day which is one of landmark judgments. Abhizar, let me start by just getting the next part of the judgment up for discussion, which is the 330 days. That was an amendment that the government brought in, which included legal time. It was then discussed whether the courts would stand for it and would it be plausible, feasible. They've given a way out of it. How do you read that part of the judgment?
No, they basically said that the 330 days is not mandatory, but there should be every endeavor to complete a case in that particular time. So, this is really what, in lay language, what the Supreme Court seems to suggest. Now, first of all, there are various versions of this 330. Version 1 is that when you talk about litigation, that litigation does not include the final approval of the plan or the litigation that follows an approval of a plan, because everybody constitutionally would have a right to approve, have a right to appeal, and those appeals would have to be heard. The other thing is that the approval of the resolution plan by the NCLT, NCLAT, or whatever the authority is, should have been completed in 330 days and thereafter open to appeal. So the insolvency process or the IBC process effectively has to conclude in 330 days. And thereafter, if there is litigation and an appeals process, that can happen later. Now, if you read this with an earlier Swiss Ribbons judgment, where the Supreme Court also said that unless sorry, not Swiss judgment, earlier SR judgment, where it said that unless there is a resolution plan already submitted and approved by the committee of creditors with the courts should not encourage litigation. So if you match the two of them together, what you will find is that first of all, there is a clear path laid out to make sure that in 330 days, a resolution plan is put in for approval with the courts, and the courts approve it within the 330 days. And thereafter, if there is litigation, there should be some. I don't think that clarity has come out. What this judgment has simply said is 330 days does not apply, and people now need to make sure that judicially they make a conscious effort to achieve it. I personally think that one of the biggest lacunas of IBC has been that none of the deadlines as prescribed under the Act actually applies to the courts. And I'm sorry, but I have been candid about it. That is really one of the reasons.
Yeah.
So had there been a clarity to say that there can be appeals post 330 days, but in 330 days the plan is approved, that would have been a better answer.
Okay, that's an important point, and Prabal, let me come to you. And thank you for your patience. But the whole insolvency process works if lenders manage to find a suitor while it's a going concern. The more time that passes by, the more value is destroyed, and that's something that the judgment speaks about as well.
Yes.
Even as we talk about the clarity that has come from the judgment, do you think that the time limit is going to be an issue?
See, Tamanna, I mean, we can only go by international precedents here because this is a very new, nascent law in India,
Yeah,
right?
absolutely.
And international precedents are twofold. And in both counts, we are not badly off. One, when the IBC was, or the bankruptcy code was introduced in the US, it took 5 years for it to stabilize. Whereas in India, it's taken about, let's say, 3.5 years. With this law, it is now settled. So that is one aspect. The second aspect is in terms of the timing. Roughly the average is about 365 days internationally for these cases to be settled.
Okay.
So we are doing 330 days. With SR, of course, SR is an outlier. So with SR, the average would have been about 600 days or thereabouts. But as of today, if you exclude SR, we have been managing within 330 days, roughly. So that's where it is. So I don't think it's too bad. Yes, I agree with the earlier speaker saying that a little more clarity on that may have been okay. But I think in practicality terms, the Supreme Court has left that door open for people to sort of not misuse the system, but at least have that flexibility. So 330 days looks by and large okay in international norms as well.
So that is the point on the time limit, but I think the key takeaway from here is about who gets how much. To put it very simply,
Yes.
It's all about who gets how much when a company goes bankrupt. It's at the end of the day, it's all about that, and that's very key to determine, because you want these companies back on their feet if possible. You want lenders to pull some money or recover some money if they can, and in a larger economic perspective also that's key. Let me come back to Mr. Shroff on that very salient point, and you explained it in great detail, Mr. Shroff, but do you think that there is going to be any sort of discretion now applied? Because now that the COC effectively has the last say, you have a waterfall arrangement in place, but the COC also has the final say. It has some discretion. How do you see all of this working out further, or do you think now it's clear in black and white about which kind of creditor gets how much in how much time?
My feeling is that with this judgment, the element of discretion that was available with the NCLT or the NCLAT has been severely curbed. Their role has been basically pinned to the issue of ascertaining whether the law under the IBC has in any manner been breached. So that if tomorrow, as I was if I was to look at it, has there been a breach of the express terms of the law? Namely, is there a delay in payment to workmen? Is there a delay in payment of the costs of reconstruction? Is there a delay in payment of the dues owed to a dissentient financial creditor? Is there a delay in paying the operational creditors within the time frame prescribed? those are the kind of issues where the tribunal has discretion. It has the right to examine those questions, and if there is an error, they have the right to demand it back to the committee of creditors to correct those errors. As far as the element of how much to pay between the secured creditors and unsecured creditors, this was a matter which was directly in issue in the case, because the tribunals exercised their muscle in a sense by saying that we will not approve till you consider the question of giving equal or giving more than what you are getting in the interim period on principles of what they felt was equitable, not what the buyer felt was equitable. Because ultimately it's the buyer's judgment to revive it. Ultimately, it's the buyer's money which causes that. Because if there is no reconstruction and there is no payment plan which is acceptable to the secured financial creditors, there will be no revival. So structurally, what happens is that they will take a haircut, the senior secured lender. They will agree to work at a lesser payment, which will arise from a novation of the contractual dues of when they are liable to pay. There will be a waiver of interest, there will be a waiver of penalties, there will be a waiver of compound interest. All those are the reason why, if at all, the operation creditors land up in money. If the lenders go on the theory that we are not going to give up any haircut, then there is no chance in hell of the operational creditors getting anything. So they have already made sacrifices when they seek to approve a resolution plan. They already contemplate that the new incumbent who's coming in has to provide money besides the haircut payment that they take. They have to bring in monies for the working capital. They have to bring in monies for payment of dissentients. They have to bring in money for operational creditors, because it is not just one issue, namely the payment of monies to the secured lenders, that revives the company. It is all the ingredients, all the stakeholders must have a balanced chance, must have a balanced output in a resolution plan. So to say that a secured creditor should be entitled to 100% of the financial plan that has been put out would be unfair, because if the trade creditors, if the working capital is not provided for, the company can't revive. The long-term creditors who are secured creditors have necessarily to examine whether there is cash in the system, whether the supply chains are kept intact, whether the services which they need are kept intact. So when you prepare a plan, it is not merely a recovery plan, it is a revival plan.
Yes.
It is to ensure that the workmen get a job. It is essential to see whether they can get paid exactly what they were getting, or whether a negotiation can be done to bring them down. So when the Supreme Court says that you have the power to examine, it is saying that in the context
No,
of
but
the primacy of the COC.
yes.
They have not given the discretion either to the tribunal or the appellate tribunal to displace the core commercial reasons why the committee of creditors took a view.
Okay.
This is critical, that you can't change the commercial bargain, but you have to also see other stakeholders' interest. You cannot be totally selfish and say, pay me everything and the company will run on its own. That's not possible. And that is the purpose of this particular judgment. I had also a separate interpretation on the word mandatory. If you feel I have the time, then I'll say what I want on that.
On that, Mr. Shroff, I just want to also go to Abizar on the key point. So at the end of the day, as of now, the COC decides who gets how much effectively. Is that the right way to understand it? And can we hope that they're fair?
I quite kind of,
Can we hope that they're fair? Because
yeah,
most
so
of
I
them
answer
will be
both of
made
them.
of financial
I
lenders.
personally, Tamanna, I'll first of all we should stop suspecting everybody every time in an IBC situation. I'll actually take it up from where Mr. Shroff left off, and I quite agree with him. In summary, there is a check and balance in the whole system. It's not that the creditors, the financial creditors, can just demand all the money for themselves. It's never going to be a case. There's a pot of money decided by a bidder based on the enterprise value of the company. And that's what they're willing to pay. Believe me, no bidder is really interested in what is the outstandings of the financial creditors. They are interested in what is the enterprise value. Then the question is, they want to have a say, and that's why it's also important that the resolution applicant decides who gets paid how much. And the creditors, of course, approve it. The reason is that they would say, I set this pot aside for existing critical creditors, existing employees, workmen, exactly as Mr. Shroff said. And hence, the balance is available to be paid to the lenders. If that kind of, it's built into the plan, and that check and balance is that the resolution applicant will protect the enterprise and accordingly distribute. The bankers will then have to decide whether that is enough for them as an enterprise, and what is expected, or what is enshrined, by the way, in the IBC Act and the BLRC report earlier, is that the committee of creditors is a trustee for all stakeholders. And they do have to take decisions based on that. And that's the reason why the Supreme Court judgment now also talks about that the committee of creditors has to be reasonable and responsible. And it's very important that that's built into the system. So I think by leaving it to the committee of creditors to decide the fate, or the financial creditors to decide the fate of a resolution plan, is very critical. It will be very naive of them to simply reject a plan just because there is some amount going to unsecured creditors. I'm dealing with situations where, for example, right now there are unsecured retail creditors, financial creditors. And there is a good accommodation among the secured creditors to say we should pay these unsecured retail creditors, because otherwise it will cause a bigger issue in terms of sustainability of the organization. So I do think that the creditors are getting there in terms of taking more mature calls to, as again Mr. Shroff said, revival of businesses as against just recoveries. So I think there is a lot more maturity in the system. The system, as again was said earlier, that we have matured faster than the US. I think we need to mature even more faster. But whatever we have done, I think the checks and balance does exist. Otherwise, the resolution plan will fail. And today's times, nobody can afford a liquidation. So that's also true.
Well, there are companies that are heading to liquidation as well. Prabal, just give us a perspective of what we've seen in the entire IBC process. And I think you made a good point when you said that Essar is an outlier. It's taken 800 plus days.
Yes.
But then a lot of things happened. The promoters tried to get in. There were many suitors. So there has been a whole history with Essar.
Yes.
So we keep that aside and look at the other broader picture. The question comes down to who gets what.
Yes.
And then the question is, if the COC is deciding, who comprises the COC? It's the lenders.
Yes.
It's the financial lenders largely who will have the most say.
Yes. Yes.
Abizar made a good point that don't be suspicious of everyone, but then the question arises that will they
the check and
follow this?
balance?
Yeah.
What is the check and balance? You see, all the good points which Mr. Shroff made and Abizar made as well. There is one other point which I think we should think about, and which is that the operational creditors are getting less and the financial creditors are getting more. That is the basic thing, right? The operational creditors, by definition, take the risk on only one business cycle.
Yes.
Whereas the bankers, etc., are taking across the multiple cycles.
Do you
right?
see them pricing it in? Operational creditors pricing it in?
Absolutely, absolutely. So that is where the moral hazard was. That on one hand, by the earlier judgment, you were taking away the risk versus return profile completely. So everybody would become unsecured creditor as per the earlier judgment was concerned.
Yeah.
So I think that needs to be kept in mind. And there is a check and balance, but then, and it's a democratic process. Now, obviously, in India, we do the Jugaad method and all of that. We know all of that. So there is, well, I guess in this case, we'll have to depend on the committee of credit
and we'll
as
wait
formed.
and see.
Yes.
Let's be honest, the IBC has been around for 3 odd years.
Yes.
We're figuring it out as we go along, in a sense. So you have to keep that in mind. Mr. Mittal, let me come back to you with a broader perspective on how crucial this judgment is in sort of unlocking the entire NPA crisis within the banking sector. Because that is, of course, on the one hand, you want to revive businesses that can be revived, but this is also about piles of bad debt choking up our financial system.
I think, Tamanna, it is very crucial. This issue of supremacy of COC was absolutely important. And I'll add one more point, that any financial creditor in COC, in one case it may be a secured creditor, in other case it could be unsecured creditor, in third case it may be a lender to an operational creditor. So I do not find any reason why any creditor would like to take a very unbalanced view. So they will always take a balanced view from all perspective, because in another case they could be sitting in the other side. The second point is that, to unlock this process, there are still some litigations on principles pending in various courts. My sincere urge would be to government to see that those cases are expedited and hearings are expedited and those cases are decided finally, so that these principles which are still pending in various courts, they are really finally decided and adjudicated and settled. But this itself was a very major decision, that whether COC is the final body or not, and NCLT was also changing, then NCLT was changing. So this issue now need to put to rest, and I am confident this will speed up the process of resolution, either for restructuring or for liquidation, either way depending upon the case of the company. So I feel it is a very crucial decision. I think the banking sector has already responded today positively.
Yes.
And as people read it tomorrow, or Monday rather, they will see that the banking sector will still start coming up better.
Absolutely, it's a huge shot in the arm for the banking sector for sure. But in the broader economic perspective, I want to come to you, Abizar, on that as well. How crucial is it to have a workable formula? As we let me just put it into perspective. We're in the midst of an economic slowdown. You'll possibly have more companies which need to go through this process. There's already a backlog of some, apart from the much touted dirty dozen. The importance of having a workable formula, and does this set the path for that?
So I think the importance of a working formula is almost required. But you know what? IBC is not a panacea to all problems. We got to understand that too. For example, the RBI has come up with the 7 June circular. And it's a very effective way to get resolution done much earlier. So the essence of IBC or resolution per se is that the quicker you do it, the more value you will get. If you do not retain the enterprise value in a particular company, frankly, there is no way you will recover any money. There are companies who faded away, especially service companies. So I think it's very important that the idea of resolution in a quicker manner is something that is incorporated in our minds. So while IBC was a paradigm shift of a law, the paradigm shifts in the minds of stakeholders has to happen quicker than it's happened. We're better than the US, but it has to happen even quicker. In terms of figuring out that yes, losses is something that can happen, businesses can fail. There is no harm in businesses failing. But how quickly do we get out of those businesses and redeploy the cash into a better, in a better way is really what the financial creditors will need to focus on. The businesses will then need to, if the time is reduced. So for example, when I talk to foreign investors, they keep telling me that the duration of doing a transaction in India is really, really long. And that's because we have multiple stakeholders trying to achieve a objective. So we need to cut the time short in terms of being more quicker in terms of our decisions. So I think if we achieve that, we won't require too many regulations or interpretations after that.
Let me bring Shardul in on that broader point. And Mr. Shroff, you wanted to speak
about. Can I intervene for a point?
Yes. Okay. Yes, Mr. Mittal. Yes, please make your point before I go ahead.
So what has been said, let me take it further. We should amend the FRC Act to bring the the principles of IBC there, so that financial creditors can sit together with everybody and take a call when the company can easily be revived. When a company is dragged on for 3 years or 2 years, it becomes really sick and it's difficult to revive it. And in any case, creditors as well as all kinds and as well as operational creditors, they don't get value out of it. So there is a need for us to see that those who have lent the money, they are more responsive and more responsible to see that company can be revived earlier. And for that, there is some tinkering with this FRC Act needs to be done straight away. Otherwise, our process of IBC to NCLT will never be able to take the load for liquidation as well as for restructuring. Why restructuring cannot be done by banks, I fail to understand. There used to be guidelines by RBI which are more in terms of guidelines but never mandatory on the banks. So some bank will not agree, but that stage has to go. The same principles must be brought into FRC Act. We should make it mandatory, and then you go ahead with that. So that will ease the process of NCLT, the IBC process. Then bring only cases which are primarily for liquidation, which really was the intention. The restructuring should be done outside that primarily, unless there are cases which can't be agreed there. But they should be very few. So that I think is a very fundamental way, and if that could be done easily, that can be done very easily by the government, then it will really boost up the market in terms of the sentiments.
All right. Mr. Shroff, let me go across to you. That broad, perspective that I've been asking everyone for. I want you to comment on that. I know you want to comment on the use of the word mandatory that the Supreme Court used in the context of the 330-day time limit, if I'm not mistaken.
Yeah. So my interpretation is that the Supreme Court has struck down the statement in the law that 330 days is mandatory. They have not tinkered with the timetable that is prescribed: 180 days, 90 days further extension, and a 60-day further extension. They have basically taken up the line that the judicial process does not strictly fit into the framework of an undisputed resolution plan. So if you didn't have any litigation at all, then your optimal time of 270 days will work. It is only because the court intervenes and takes matters to itself, whether at the NCLT level, whether at the NCLAT level, whether in the writ courts, that a delay is introduced. Now, the previous judgment of the Supreme Court clearly said that whatever time is taken by the court cannot harm the litigation, and therefore the exclusionary principle of time taken in the court was the view the court held. But now that all the principles on the basis of which stay orders were granted, on the basis of which the writ petitions were allowed or taken into consideration, most of those litigative issues have been settled. So my own perspective is that there is very little chance of trying to take up a new legal issue and going to court and stalling the matter. There is also the principle that where there is an alternative remedy provided, courts should not interfere. And that principle will clearly apply in the issue of NCLT and NCLAT. There is an intra-appeal which is already inter-appeal between NCLT and NCLAT. That is already prescribed for the courts, therefore, to go into constitutional questions when the Supreme Court has cleared the constitutional validity of this law twice, if not once. There is no need for the high courts now to intervene. And as Mr. Mittal clearly said, that there needs to be a review now of how many cases are pending on what legal issue. And since there is a finality now on most of the legal principles that were stalling the decisions, those should be decided on the basis of the principles laid by the Supreme Court. There is no need for them to drag on. They should be just put into buckets of types of cases and disposed of on the basis of the principles that the Supreme Court has set. Right. And that will accelerate the entire process of either resolution or liquidation. So this is one remedy, as I see, should follow, because there is no other major legal issue now pending before the Supreme Court or any court for that matter on the interpretation of the IBC.
Absolutely.
This was one of the reasons why I felt that it really doesn't matter whether they've knocked off the word mandatory, because the very reasons or the causes for which the courts intervene are all gone.
Right. All right. I'll have to end it here, but I want to thank all of you for joining us on this debate. I hope our viewers have got some clarity on why this judgment is so important, why it's being hailed as a landmark verdict, and at the end of the day, if we can speed up the process, bring to resolution quickly enough, companies that have gone bankrupt for whatever reason, it would only help in unclogging the financial sector as well, which forms such a core part of what is happening in the economy right now. So I want to thank all of you for joining us on debate number 1. We're taking a very short break, but when we come back, we're talking politics. Are we going to see a government in Maharashtra? Who's going to form it? How stable will it be? All of those questions come to the fore after the NCP has made it clear that it is going ahead with the Shiv Sena and the Congress to form the next government. How does this all pan out? We're coming with complete analysis after this break.